Hello and good evening, and welcome to today's special report. Tonight we delve into a landmark case that has reshaped how we look at responsibility in construction project. In November 2016, a tragedy struck when a pedestrian bridge connecting KL Eco-City and also Mid-Valley City collapsed during construction. So this event claimed one life and left two individuals seriously injured and raised significant legal and safety questions. So, the legal battle that followed was between KL Eco-City and the developer and also two critical parties, Tort Engineering and Construction, the contractor, and Hercules Engineering, the designer and fabricator of the bearings supporting the bridge. At the heart of the case was a fundamental legal question: who bore responsibility for the collapse? Was it a breach of duty by the contractor and designer, or did the fault lie elsewhere? So the case of KL Eco-City Sendirian Berhad and Tort Engineering and Construction Sendirian Berhad and another 2020 MLJU 435 was heard and tried in High Court Kuala Lumpur by the Judge Lee Swee Seng. This case involved two areas of law, which are contract law and also tort law under negligence particularly. So the court's decision also serves as a critical precedent in determining liability in complex technical issues, while this case also addresses key issues such as the duty of care owed by contractors and also designers, the role of design consultants, and also the importance of safety and redundancy in construction projects. Imagine a dazzling pedestrian bridge meant to connect two iconic landmarks in KL, which are Mid-Valley and KL Eco-City, designed not just as a crossing, but a statement of modern engineering and aesthetic. A curved bridge to catch the eye. However, on a fateful November 2016, this ambitious structure collapsed during the construction and leaving devastation in its wake. The three key players here are KL Eco-City, the developer of the bridge, Tort Engineering and Construction, the contractor tasked to build the bridge, and Hercules Engineering, subcontractor to design and fabricate the bearings. KL Eco-City blames Tort Engineering and Hercules Engineering under the tort of negligence and breach of duty, claiming that they did not build the bridge properly and the bearings could not handle the load. However, Tort Engineering argued that they had followed the design specifications given, and Hercules Engineering had built the bearings based on the specification given by the plaintiff. So having taken a look at this case, I could not help but wonder, did the second defendant actually owes a duty of care towards the plaintiff? Now we are going to meet one of the lawyers who attended this proceeding to ask that question. Hi. So actually in this case, did the defendant too actually has the duty of care towards the plaintiff? So we have to take a look first. Who is the second defendant here? The second defendant is the Hercules Engineering, which is the person, the subcontractor, responsible to build the bearings. So in this case, defendant 2 had submitted that they had no contractual relationship with the plaintiff, and the LB1 bearings were custom made based on the bearing schedule, containing technical details and specifications of the bearings, including orientation and movement. Here, the materials and workmanship used in the manufacture of bearings will be tested and inspected, and the bearings itself would be tested. So the court held that the bearings were tested as required before installation. Therefore, the test results were furnished. Hence, the foreseeability here is not established, and the proximity here is also not established, considering that they had no contractual relationship with each other. Then, the court moved into the element of fair, just, and reasonable. In this case, the court was slow to impose on the duty of care, especially where the parties have allocated their risks and liabilities extensively. Here, the second defendant is outsourced contractor to defendant 1. Even though the cost of bearings provided by defendant 2 is mentioned, it doesn't mean that defendant 2 cannot be held liable just because their part was relatively cheap compared to the overall losses claimed by the plaintiff. However, price here does reflect the skill and expertise expected from the second defendant. While the second defendant's role and costs are considered, TYL, the agent of the plaintiff, should be held accountable for not adequately addressing the engineering challenges that led to bridge collapse due to the fact that they are the civil and structural engineer responsible for designing the bridge. Here, the court referred to the case of Siemens General Contracting Co. and Pilkington Glass Ltd 1988. The judge here said that the foreseeability of harm does not itself automatically lead to duty of care. It is a necessary ingredient, but not the only one. Hence, in this case, there was no good reason for the court to impose the duty of care towards the second defendant. Hence, the court held that there is no duty of care towards the plaintiff by the second defendant.
A few moments later.
Hey, friend!
Hi.
Oh, she's my friend from different firm. So, I just want to know, the case that we talked earlier
Yeah.
was whether the second defendant and the first defendant had breached their duty of care towards the plaintiff. I just want to know that.
Okay. So when considering whether they had breached their duty of care, the court firstly began by examining whether the contractor, Taksin Engineering, and the bearing designer, Hercules Engineering, acted reasonably. So reasonableness is judged by the standard of a competent professional under similar circumstances. Evidence showed that Taksin Engineering constructed the bridge exactly as per the approved design and specification provided by the plaintiff's consultant, so TY Lin International. Similarly, Hercules Engineering fabricated and tested the bearings, demonstrating that they exceeded the required standards. Importantly, TY Lin International was invited to observe the construction process and the bearing tests on site. However, they declined to attend, opting instead to request of a report. After reviewing this report, then they approved the construction. So this approval played a very crucial role in the court's decision, as it highlighted that both Taksin and Hercules Engineering acted under explicit instructions from TY Lin without deviation. So the next question was whether the defendants could have foreseen the magnitude of risk associated with the breach. While the collapse actually had a very catastrophic consequences, loss of life, serious injuries, and also significant financial damages, the court found that the risk was not foreseeable from the defendant's actions. The root cause traced back to a flaw in the design. A curved structure like this required redundancy, which is a backup system to prevent a total collapse if one component failed. TY Lin International, as the design consultant, had not incorporated this crucial safety feature, making the structure inherently vulnerable. So, the design oversight was beyond the defendant's responsibility, and the relevant legal precedent in this case was various claimants and Catholic Child Welfare Society 2013, which clarified the limits of vicarious liability. This case emphasized that liability should not be imposed on parties who acted within the scope of their responsibility, especially when the primary fault lies elsewhere. So the court applied this principle Tribunal, ruling that the defendants, having adhered to their contractual obligations and professional standards, could not be held liable for design errors made by TY Lin International. And the court also considered whether additional precautions could have been taken by the defendants. Hercules Engineering, for instance, they went above and beyond by conducting tests that exceeded the required standards. Despite this, the bridge still collapsed due to the design flaws, not any deficiencies in the fabrication or construction. So TY Lin International's decision to approve the work based on reports without observing the process directly further underscored their responsibility in the tragedy. The court concluded that both Taksin Engineering and Hercules Engineering had reasonably acted within their scope of responsibility and they were discharged from their duty of care. So, in the final decision, the court dismissed the claims against the contractor and the bearing designer. It found that the true fault actually lays with the design consultant, TY Lin International, whose oversight in incorporating redundancy mechanisms led to the collapse. That's all.
Legal issue, we will refer to our law journalist who's already at the scene.
Hi. So when discussing the third issue, which is whether or not the first defendant and the second defendant had been negligent, we look to the elements of negligence. So negligence in this case exists in duty of care and breach of duty. So as per the court said that the court had arrived at the finding that the plaintiff had failed to prove negligence on the part of the defendants on a balance of probabilities. So as summarized earlier, there was no breach of duty committed by the first defendant or the second defendant. As we look to the standard of the duty of a professional, the first defendant had done their duty above and beyond to make sure that the bearings had been tested more than the required specifications. And as for the second defendant, the bearing designer, they had designed the bearings according to the designs made by the plaintiff's consultant, TYL. So when we look to another element in proving breach of duty, there is also error of judgment. So error of judgment, in this case, we look to the redundancy calculation. So the court held that it is only too obvious that had TYL calculated the redundancy in the designs, the design of the bridge would not be faulty and the collapse could have been avoided. In establishing the negligence for the defendants, the court also referred to the case of various claimants and Catholic Child Welfare Society in determining the relationship between the plaintiff and their agent. So when we look at TYL and the plaintiff's relationship, we can see that TYL is only following the instructions of the plaintiff, and however they design it is according to the plaintiff's demands and visions. So the plaintiff can demand what the agent designs but not how they design it. So today it is not realistic to look for a right to direct how an employee should perform his duties. However, the court dismissed the reference of this case because we are establishing the negligence that is completely separate from the plaintiff and their agent.
Hence, now that we are coming to the end of the case, we are going to see the judgment made by the court. On the first issue, whether the second defendant owed duty of care, the court held that the second defendant owes no duty of care to the plaintiff because they have exercised all of their liabilities and risks, and also there are no privity of contract and there are no close proximity of such and whatever, and there is no possibility of harm, and the end result of duty is inspected by the plaintiff, and the plaintiff are fully satisfied with what the second defendant had presented to them. Second issue, on whether the both defendants breached their duty, the court held that both defendants did not breach their duty since the plaintiff have failed to prove the faults on their part, which is whether they failed to provide the bearing that could withstand the
is no foreseeability of harm from their part. And since they fully complied to the standard of their duty, there are no breach by them. And in discussing the third issue, whether both defendants are negligent, since the second defendant owed no duty of care to the plaintiff, and since both of them did not breach their duty towards the plaintiff, we could conclude there is no negligence on both of their part towards the plaintiff.
So it's quite difficult to find this person, but I finally find her today in front of Bank Islam. Just what we expected from IUM law lecturer. Assalamualaikum.
Waalaikumsalam. Yes, how can I help you?
You are Madam Aina, right?
Yes.
So I have this question about the case that we just talked about earlier.
Oh, the bridge collapse.
The bridge collapse. So how do you think this case, the decision of this case could impact the future decision in the court?
So in my humble opinion, I think this case will impact the future decisions of the court by how it will be difficult, I think, to impose duty on subcontractor, especially if there is no privity of contract between them. The thing is because the subcontractor is actually responsible for the contractor who hired them. And the second one would be in cases like this where there are inspection by the plaintiff themselves, the plaintiffs are supposed to inspect the work done by the contractors, by the subcontractors. Hence, there is the duty or responsibility for them in order to see or foresee whether the staffs, whether the bearings in the case are actually good to go. So I think in this case, the future decisions that will be impacted are when similar cases where they have inspection by the plaintiff themselves, it will be difficult to impose duty of care towards the defendants when it is upon the plaintiff to determine whether the bearings or the stuffs that they have done are good to go or not. Oh, and in addition to that, especially when the plaintiff has known that especially when the plaintiff could discover or the defect of the cases, the defect where the stuffs are actually discoverable, but the plaintiff did not see or they did not account for the defects themselves. Like in the case that happened, the plaintiff did not come down to actually inspect the bearings itself, but rather they actually relied on the report.
As a conclusion, we can conclude that the burden of proof lies on the balance of probabilities that the defendants are completely at fault. So the competing theories must suggest that the defendants are more probable for causing the collapse of the bridge. However, the plaintiff had failed to do so. In fulfilling elements for negligence to exist on the defendant's part, it was a failure as the course of action itself comes from the plaintiff. The defendants fulfilled their contractual duty by adhering to TYL's designs and specifications. So the ultimate liability lay with TYL, whose flawed design caused the collapse and liability and can't be extended to parties that acted within their scope of responsibility. Thank you.